So in today's video, we're going to talk about the top 10 hot legal topics in the specialty pharmacy industry. The first topic that we're going to talk about is near and dear to every specialty pharmacy's mind, and that's network access. PBMs who own their own specialty pharmacies are creating exclusive networks that are shutting out independent specialty pharmacies and blocking them from gaining access to the PBM's members. These could be closed networks where the only participating pharmacy is the PBM's wholly owned pharmacy, or could be more open networks but have unrealistic barriers of entry that serve only to exclude independent specialty pharmacies. The key here is that there are tools available to specialty pharmacies seeking to gain access to these networks. This could include federal any-willing provider laws, state any-willing provider laws, or a variety of other types of tools available both from a state law or federal law to specialty pharmacies. The second topic we face is access to limited distribution drugs. These are drugs that by designation of the manufacturer have a limited distribution channel where only a select group of pharmacies can even purchase the medication. Now, there are a lot of tools for pharmacies seeking to gain access to purchase these drugs, but one of the perennial problems is the chicken or the egg issue, where in order to gain access to the drugs you have to demonstrate clinical performance through volume of prescriptions. But it's difficult to demonstrate volume of prescriptions if you can't have complete access to the drugs at the same pricing. Again, there are some tools that specialty pharmacies have at their disposal to continue to push for access to these drugs, but it's important to take it one step at a time. The third issue we face is PBM and payor audits. Now, this is nothing new to specialty pharmacy, but it sometimes impacts them on greater detail. Now, there are a lot of types of audits that PBMs focus on that are more traditional types of audits, like copayment collection, or mailing into states with a license, or inventory reconciliation. These are things that affect all pharmacies just as much as specialty pharmacies. But there are some new trends that have come out in terms of PBM audits of specialty pharmacies relating to, for example, off-label usage or turf REMS type drugs where there's this issue of medically accepted indication. The important thing here, however, is that there are tools available to specialty pharmacies, for example, fair audit protection laws and prompt payment laws at the state level that can serve to protect against abusive PBM audits. The fourth issue we deal with is relating to pharmaceutical manufacturer relationships. Now, this has emerged as a huge issue in the specialty pharmacy space and could take a variety of different forms. This could be as simple as a copayment collection and patient assistance program. It could be volume-based discounts. It could be a prior authorization framework, or it could be a data reporting framework. The important thing here, however, is that all of these relationships be vetted not only from a regulatory compliance perspective, but also from a PBM compliance perspective. One of the things we're seeing a lot with PBMs is the scrutiny of relationships between pharmacies and pharmaceutical manufacturers, because PBMs are growing increasingly concerned about captive pharmacy type arrangements where there's too close of a relationship between the manufacturer and the pharmacy. The fifth issue we deal with is a concept of financial transactions involving specialty pharmacies. Now, this could be something as simple as a pharmacy acquiring another store and doing a merger or an acquisition, or it could be a concept where the pharmacy is having a very large financial event, such as a private equity firm is coming in and taking a stake within the pharmacy. There are a couple of key components and key considerations that all stakeholders have to have when engaging these types of transactions. This includes not only regulatory due diligence, but also a form of contractual due diligence where not only are the past practices of the pharmacy evaluated from a regulatory and legal compliance perspective, but the types of contracts that the specialty pharmacy has with, say, the PBMs come into play. And it also requires the consideration of what the change of ownership will do, not just to those contracts, but also in terms of reporting requirements to entities such as the Board of Pharmacy or Medicare. The sixth issue we talk about is hub models. This has become an increasingly hot topic among specialty pharmacy conferences and meetings, and it's a situation where either networks of pharmacies, health systems, or pharmacies aligned with manufacturers enter into an arrangement to facilitate the sharing of services and information by and among those entities. It could be directing prescriptions based on licensure access, based on limited distribution drug access, or based on payor access. The important thing here is that these comply with HIPAA along with applicable state and federal laws relating to referrals, because again, it is possible that prescriptions could be referred or directed through these models, and there is the possibility of the flow of money by and among the parties. The seventh issue we address is the concept of reimbursement. And one of the important concepts here within the reimbursement is the DIR fees. Now, one of the recent trends that has emerged, particularly as PBMs start to open up their previously exclusive specialty pharmacies, is the concept of PBMs agreeing to allow people in, but paying them below market, below acquisition cost. Now, there are some tools that pharmacies can use to fight these. Medicare requires all Part D plan sponsors to pay a reasonable charge, and paying below acquisition costs isn't a reasonable charge. Now, there's another concept, DIR fees, or direct and indirect remuneration. This is a concept where the PBM is later clawing back money from the specialty pharmacy under the aegis of a performance fee, and it's something that's being done after the point of sale, after adjudication, and it's extremely hard for the pharmacy to keep tabs on it. There are, again, tools available to pharmacies seeking to challenge this type of abusive PBM conduct. The next concept we deal with is the concept of accreditation. This is again becoming an emerging topic, a more increasingly important topic among specialty pharmacies relating to their accreditation with different accreditation bodies so that they can gain access to certain closed or exclusive specialty pharmacy networks. There's the concept of dual accreditation, where pharmacies get more than one accreditation so that they better their chances of getting in. But there's even emerging a new trend where accrediting bodies are terminating or revoking pharmacies' accreditation, and it becomes a very cloudy, murky concept. The important thing here is that pharmacies be aware of their contractual rights with these accrediting bodies and maintain vigilance as to the independence and judgment of these accrediting agencies. Another issue that comes up a lot for specialty pharmacies relates to government investigations. This is a situation where a government agency, for example, the FDA or the Department of Justice or the OIG, comes in and decides to investigate a particular specialty pharmacy for one or more types of conduct. This could include a subpoena or other types of tools available to the state or federal governments to investigate a particular healthcare provider. Now, it's important to not only be prepared for a government investigation before it happens, but also to have experienced guidance while going through a government investigation. These can focus on relationships between pharmacies and doctors, pharmacies and patients, pharmacies and manufacturers, and it's important to have all of your relationships fully vetted from a legal perspective before entering into them. The last issue we talk about today is that of the 340B drug program. The 340B drug program allows for covered entities such as disproportionate share hospitals or children's hospitals to be able to purchase certain types of drugs at a reduced cost with the idea that they're going to pass some of that savings along to the indigent population or the low-income population. Now, there's a unique arrangement that specialty pharmacies can enter into with some of these covered entities relating to a contract pharmacy arrangement. Under this contract pharmacy arrangement, the pharmacy is able to dispense the drugs that are purchased by these covered entities and be able to dispense it directly to the patients and receive a dispensing fee or other type of fee from the covered entity. Now, there's a couple of important concepts here relating to not only compliance with the overall 340B program, but ongoing HRSA audits that are conducted to ensure that level of compliance. And so not only specialty pharmacies, but also covered entities will require a level of competence, a level of guidance as it comes to the compliance with this program. Again, that's the top 10 list of the hot topics among specialty pharmacies. Hope you enjoyed it. Look forward to talking to you soon.